I'm Harry Teichman. I'm a partner with Taylor English Dumas, a full-service law firm with a national practice. I'm talking today estate planning for the business owner and entrepreneur. The business owner and entrepreneur has a little bit different profile than your average estate planning client, and that is that the vast majority of a business owner or entrepreneur's estate is typically a privately held business, as opposed to stocks and bonds, which are easily valued, bank accounts, which are easily valued, and even real estate, which is fairly easily valued. A privately held company has many different components of value, especially when it comes to estate and gift tax planning. And value is important in order to determine what type of estate planning a business owner needs. I think the most fundamental issue that needs to be fleshed out when a business owner or entrepreneur asks for my advice on an estate plan is your estate at this time around the $25 million range? And do you think that your estate is actually above 14 million? And the reason those two numbers are important is as follows. In 2017, the estate tax credit, meaning the amount and value of an estate before the estate tax applies, was raised substantially to about $12.5 million for an unmarried person and about $25 million for a married couple. That means that if there is a married couple who has an estate in excess of $25 million, that couple should consider whether or not they would like to do some tax planning for their estate for federal estate tax purposes. And that $25 million value is set to sunset in 2026, meaning that if Congress does nothing else to this estate tax credit, it will revert to its pre-2017 levels, and there's an adjustment for inflation. And typically folks believe this is going to be in the $6 to $7 million for a single person and 12 to 14 for a married couple. And so now is a good time for a single person or married couple when doing estate plans to determine, are we above 25 million because we should do something now? And do we believe that our estate is going to be worth more than $14 million or $7 million if it's a single person in 2026, so that some proactive action should be taken now in order to work on reducing that amount. So once it's been determined that there's a taxable estate, the estate becomes far more complex. And the reason why is that for every dollar above that exemption amount, the tax is roughly 40%. So it's a pretty hefty tax that you are leaving your heirs with. Made worse if it's in illiquid assets, because they still have to come up with the money. There are some certain time frames for small businesses that can pay over time, but usually it may cause a distressed sale of a business if there's no estate planning done and it's passed on to the next generation. And that's taxable estate. But let's assume you are not in the taxable estate area. That type of succession planning or estate planning is simply an analysis of who do you want to leave your assets to? Who does the business owner wish to leave the assets to? Now, typically the business owner, if you're married, typically it goes to the spouse, and then it may go to the children. And that's typically done with what I consider to be a pour over will and trust scenario, meaning we draft a will for you. The will typically says everything that I own at my death passes to this trust and is held in the trust. And the reason I like to use a trust is that it avoids the creditors of the heirs you are leaving the money to, and it can also be used in case your heirs are young. So, for instance, obviously someone with small children would like to make sure that things are left in trust for that small child. You can't leave a business to a small child. The child can't run it. Obviously, the child can't own it. So typically you have a trustee that manages that asset for the child until the child reaches a certain age as set forth in the trust. This also works, with folks in their, teens, 20s, even 30s. The business owner may not want to leave the entire business to a 20-year-old or 25-year-old. So a trustee is typically something that is appointed in the documents, and that trustee will run that business until such time as it's either sold or turned over to the beneficiary, because the beneficiary is old enough to run the business. Obviously, there are other folks that people may consider with businesses. We work on buy-sell agreements all the time, meaning maybe there's a business partner involved. If one of the two business partners pass away, they buy the business back from the other deceased partner. So in other words, this provides liquidity for the family of the partner that passed away, and allows the other owner who's been running the business all along to take over the business, run it, but pay an agreed upon amount to the family of the deceased partner. That's typically done in a buy-sell agreement, and then what you deal with then is simply the assets or the proceeds of that sale in a trust to be held for future generations. It's important to note that separate estate planning works typically with assets held in one spouse's name if it's a married couple. Jointly held assets typically pass, no matter what jurisdiction you're in, to the surviving spouse. So no documentation is necessary for that. But if you don't have a surviving spouse, or someone wants to leave the business assets to someone other than the surviving spouse, that needs to be dealt with as well in the estate planning documents. But in particular, this is important to business owners because most small business owners and entrepreneurs own all or part of their business in their own individual names, so that it does apply and will apply upon the death of that business partner. Those assets will need to go through either the probate process or be held in the name of a trust, so that they can pass either on to the spouse or on to other beneficiaries that business owner has named. So finally, there's capital gains components as well, which we deal with as part of the estate plan, because capital gains, you get what's called a step up in basis now upon death, meaning whatever the business is worth at the time of your death is the value to your heirs if they sell. So a business owner that owns a piece of a business that maybe that business owner started for $100 that is worth $5 million at the time of death, those surviving beneficiaries that receive that interest, in other words, if you leave it to your kids, the kids will take that business not at the $1 amount or $100 amount that was started with, which is what the business owner would have to sell and pay tax on. Those kids could turn around and sell it for $5 million, and they would receive no income tax on that sale. So that also comes into play in the business owner or entrepreneur's estate plan. So overall, two major items to consider. One, what is the value of your estate? For small businesses, if you're starting to look at the $7 to $14 million for a married couple value, now is the time to consider estate planning. Valuations are done by typically valuation experts. You don't want your own in-house accountant to do it. You want to provide them if there's any gifting that takes place, which is another technique you can do to reduce your estate during life. We want to have appraisals of those assets if you believe you're in the $7 to $14 million range, or even the $25 million range. You want to have appraisals done of those assets. After that, we can discuss what type of estate plan you may want. So reach out to your Taylor English attorney as we move into the sunset time, the 2025-2026 period. Now is the time to consider whether or not you're going to be above the sunset amount, and don't rely on Congress to raise it back to $25 million again, because they're very busy right now just trying to keep the government afloat. Thank you.